Well, in the U.S., there are several laws that protect workers while they're on the job. They can be very tough to understand. So today, attorney Jim Higgins is explaining things a little more thoroughly. Better Nashville's Jenny Gaither has more.
So your firm handles a lot of workers' comp cases, and I know that everyone is different. Do you ever work outside of just the Tennessee comp case law, or how does that work?
Well, that's such a good question because been doing work comp for about 18 years, and what we've learned over the years is that often there are laws that people never look at outside the Tennessee Work Comp Act that help people. And the biggest ones we see are the Americans with Disabilities Act and the Family Medical Leave Act, and also we run into some overtime claims a lot of time under what they call the Fair Labor Standards Act.
So how can a person maintain their job even if they file a workers' comp claim? Do they have a right to make sure that their job is protected when they can come back?
Yeah, well, there are certain protections in each of the acts that we talked about. One, you can't be fired for filing a work comp claim. That can be hard to prove sometimes. The law protects you from being retaliated against by your employer. But some of the biggest protections and the cleanest protections are, for instance, the Family Medical Leave Act. It protects your job if your employer is big enough for 12 weeks. So that gives you time to recoup, get back, and hopefully you're well enough to go back to that job. And in 12 weeks, your job has to stay there. The other act that's really important for people we found is American with Disabilities Act, because what happens a lot of times if somebody has a permanent injury, then they may be left with some type of disability. But as long as they can perform the essential functions of the job, is what the law says, and then they can go back. The employer cannot fire them because they have a medical restriction or some other problem, as long as the person can perform the job and a reasonable accommodation can be made if necessary.
So what would a reasonable accommodation be?
Yeah, that's the toughest. There are extreme examples of that in our ADA cases. And for instance, if I have somebody that the doctor says, you know what, this guy, he just needs to sit a couple of minutes out of every few hours. So it can be as simple as bringing a stool for him or a chair. And that would obviously be something that I think most courts would say, hey, that's pretty reasonable. It doesn't cost a lot. It doesn't interfere with his job. That's something that this person can do and still make a living. Now, on the other end, if a person says, well, hey, I need you to build me an elevator so I can get in, then that would not be a reasonable accommodation. Of course, there's a lot of gray area in between, so it really is just a case-by-case basis.
Right, and I guess it probably determines whether or not you work for a bigger company or a smaller company, maybe?
Yeah, you know what? Some things are more of a hardship on other companies, and a lot of the bigger companies, they have the resources, they've had the means, they've hit other ADA claims before, so they are a little more, and hopefully a lot of times they're more able and willing to help somebody to give them some type of reasonable accommodation so they can support their family and earn a living.
Well, there certainly are a lot of legal technicalities that you have to work through with the workers' comp case, so it's probably best to have a professional like you on your side to help you weed through all that paperwork and everything that people may not know, right?
It's always good to have a professional to talk to.
All right, well, thank you so much for meeting with us today.
Thank you.
The Higgins Firm is serving Tennessee. Call them at 615-353-0930. Or for more information and a link to their website, just go to betternashville.com.